The letter was sitting on my workbench when I got home. Bright yellow paper, HOA letterhead, the kind of thing that makes your stomach drop before you've read a single word. But it wasn't the letter that stopped me cold. It was the silver Mercedes S-Class parked inside my private workshop, engine ticking as it cooled, right next to my arc welder. HOA President Diane Hartwell had used a duplicate gate key, one she had no legal right to possess, to park her personal vehicle on my deeded private property, and she had done it like it was nothing. My name is Garrett Ohlsen. I'm a licensed industrial welder, and I own a half-acre property at the end of Sycamore Ridge Lane in a planned community in suburban Ohio. My detached workshop sits entirely within my lot lines, surveyed, certified, recorded, and it has its own vehicle gate with a motorized lock. I built it legally, permitted by the county, reviewed by a structural engineer. It is mine, completely, legally, undeniably mine. Before I tell you what I did next, and I promise you it was completely lawful and deeply satisfying, I want to ask you something. If you've ever dealt with an HOA board member who acts like your property is their personal jurisdiction, you are not alone. Stories like mine are playing out in neighborhoods across the country right now. If you want to understand how to protect your property rights using actual U.S. law, subscribe to HOA Problems. We break down real cases, real statutes, and real CC&R contradictions every single week. To understand why Diane was in my workshop at all, I have to go back 3 months. The Sycamore Ridge HOA had recently adopted a revised parking ordinance, Addendum 7C to the CC&Rs, which restricted uncovered vehicle storage visible from the street in driveways. Fine enough. My workshop sits behind a solid cedar fence, completely invisible from any public road or neighboring lot. It doesn't touch the driveway. It has nothing to do with Addendum 7C. But Diane had decided otherwise. It started on a Tuesday afternoon. I was pressure washing my truck in the driveway when Diane's white Lexus slowed to a crawl in front of my house. She rolled down the window. "Mr. Ohlsen," she said, with that smile that never reaches the eyes, "we've received a complaint about your workshop structure. It may be in violation of the community aesthetic guidelines." I told her calmly that the workshop was county permitted and fully within my lot. She nodded like she hadn't heard a word I said and drove away. 4 days later, the first official violation notice arrived. It cited Addendum 7C, the Aesthetic Guidelines Clause, and referenced something called Section 12 Structural Oversight, a provision I had never seen in any version of our CC&Rs. The notice included a $60 fine and a 14-day cure period. I photographed it, logged it in a spreadsheet, and did not pay it. Instead, I submitted a formal written response via certified mail requesting the exact textual basis for Section 12 Structural Oversight and a copy of the amended CC&Rs in which it appeared. They never sent it because it didn't exist. What they sent instead, 11 days later, was a second violation notice, this time citing potential encroachment on common area drainage easements, with the fine escalated to $150. The language was deliberately vague. The notice didn't specify which easement, which survey boundary, or which drainage infrastructure my workshop allegedly threatened. This is a classic HOA escalation tactic. Expand the accusation when the first one doesn't stick. I want to pause here and explain something important about how CC&Rs actually function under U.S. property law, because this matters. CC&Rs, covenants, conditions, and restrictions, are recorded legal documents attached to your deed at the county recorder's office. They are enforceable contracts, but they are not unlimited. They cannot override state statutes. They cannot contradict your original deed. And critically, they cannot be retroactively applied to improvements that were completed before the addendum was adopted, unless the CC&R specifically grant that retroactive authority, which most do not. The third letter arrived certified, return receipt requested. Diane was accelerating. This one threatened a lien against my property if the encroachment was not remediated within 30 days. A lien against a workshop that was surveyed, permitted, and had existed for 4 years before Addendum 7C was ever drafted. I sat at my kitchen table that night and made a decision. I was going to document everything, hire a licensed surveyor, and pull every recorded document touching my property from the Franklin County Recorder's Office. Every single one. I hired surveyor Marcus Webb of Webb & Associates, LLC, state licensed, insured, and certified by the Ohio State Board of Registration for Professional Engineers and Surveyors. He conducted a full boundary survey and delivered a stamped, sealed plat map within 2 weeks. His findings were unambiguous. My workshop sat entirely within my deeded lot lines, with a minimum setback of 11 feet from the nearest lot boundary. There was no drainage easement anywhere near the structure. The nearest recorded easement was a utility corridor running along the western edge of my property, 32 feet away. I also pulled my original deed from 2009, my title insurance commitment, and the chain of title going back to the original subdivision plat. None of those documents contained any provision granting the HOA the right to regulate enclosed, permitted structures on private lots. The original Declaration of Covenants, the founding document, recorded before any addendum existed, defined HOA jurisdiction as covering exterior paint colors, fence heights, and driveway surface materials. That was it. A workshop behind a fence was never within their scope. Now here's the part I want every property owner watching this to understand. Under Ohio Revised Code Section 5312, which governs planned community associations in Ohio, an HOA board is required to maintain a written record of all adopted rules and amendments and to provide copies to any owner upon written request within 10 business days. I had submitted that written request. 31 days had passed. They were already in statutory violation before the lien threat had even been mailed. Step 4 of Diane's escalation came without warning. I arrived home on a Wednesday evening to find my workshop gate standing open. The padlock had been removed, not broken, removed, and placed neatly on the ground beside the post. And there, parked inside my private, enclosed workshop, was Diane Hartwell's silver Mercedes S-Class. A handwritten note on my workbench read, "Conducting structural inspection per HOA authority, D. Hartwell, HOA President." I did not move the car. I did not confront Diane. I did the only rational thing a property owner should do in that moment. I called the Franklin County Sheriff's non-emergency line and reported an unauthorized vehicle on private property. Then I called my real estate attorney, Sandra Kowalczyk of Kowalczyk Property Law, LLC. Then I took 63 photographs of the car, the removed padlock, the gate latch, the note, and the timestamp on my security camera system, which had captured the entire entry sequence. Sandra's voice was calm when she called me back. "Garrett," she said, "this is trespass. Clear, documented, photographed trespass. An HOA president has no independent authority to enter private property for inspection without a court order, regardless of what the CC&Rs say, and even then, only with proper notice. She told me to print the security footage to a thumb drive, preserve the original files with hash verification, and send her everything. The deed, the survey, the violation letters, the certified mail receipts, all of it. A deputy arrived within 40 minutes. He photographed the Mercedes, documented the removed padlock, reviewed the access log from my gate controller, and filed a formal trespass report. Under Ohio law, unauthorized entry onto enclosed private property constitutes criminal trespass under ORC 2911.21, regardless of the entering party's professional or organizational role. The deputy advised Diane, who had returned by then, visibly shaken, to move her vehicle immediately. She did, without a word. That night I drafted a letter, reviewed and approved by Sandra, addressed to the full HOA board, not just Diane. It outlined in numbered paragraphs every statutory violation the board had committed over the preceding 3 months. Failure to produce CC&R amendments within the statutory period, imposition of fines without documented regulatory authority, and now a criminal trespass event by their sitting president. The letter closed with a formal demand for a complete dismissal of all fines, a written retraction, and a certified letter confirming that no lien had been or would be filed. Sandra filed a formal complaint with the Ohio Attorney General's office citing unfair debt collection practices, the lien threat, under the Ohio Consumer Sales Practices Act. She also prepared a quiet title action as a protective measure, which would formally establish in court that my workshop was not subject to any HOA easement or encroachment claim. The board received her letter on a Friday. Their scheduled board meeting was the following Tuesday. We were ready for it. The meeting was held in the community clubhouse. Sandra attended with me. 14 of my neighbors were in the room, several of whom had received similar violation notices in recent months and had come specifically because word had spread about what happened with my workshop. Diane sat at the head of the table with 2 other board members. She looked like someone who had finally realized how far past the line she had walked. Sandra spoke first. She presented the stamped survey plat, the original deed, the chain of title, the CC&R founding document, and the Ohio Revised Code citations. She placed the sheriff's trespass report on the table. She read slowly and clearly the statutory requirement under ORC 5312 for timely disclosure of adopted rules. Then she placed the certified mail receipts showing the 31-day non-response on top of the stack. There was complete silence in that room. The board attorney, a young man named Trevor Hollis, who looked like he had been handed this file 15 minutes before the meeting, asked for a recess. They took 22 minutes. When they came back, Diane read a prepared statement. All fines against my property were dismissed. The encroachment claim was withdrawn. The board acknowledged that no lien had been filed and confirmed in writing that none would be. A formal written apology would be mailed within 5 business days, but we weren't done. Sandra had one more item. Under Ohio law, when an HOA imposes fines that are later determined to lack documented authority, the owner may seek reimbursement of reasonable attorney's fees through the courts. She placed a fee schedule on the table. The board attorney whispered something to Diane. Diane nodded. Within 30 days, the HOA's insurance carrier issued a check to Sandra's firm covering our full legal costs, every dollar. Now let me walk you through the 5 legal frameworks that protected me in this situation, because this is the part that actually matters for you. First, your property survey. A stamped, certified boundary survey from a state-licensed surveyor is the single most powerful document in any property dispute. It is not an opinion. It is a legal instrument. If you don't have one on file, get one. Before any dispute, before any fine, before any HOA meeting. Second, your original deed and chain of title. Pull them from your county recorder's office. Most counties have online portals now. Read the legal description of your lot. Read the original declaration of covenants. Understand what jurisdiction your HOA actually has under the founding document, not just the latest addendum they voted on at a meeting you didn't attend. Addenda can expand rules, but they cannot contradict the founding covenants or override your state statutes. Third, CC&R amendment procedures. Every HOA's CC&Rs must specify the process by which new rules are adopted, typically a supermajority vote, proper notice to all homeowners, and recording at the county recorder's office. If an addendum was adopted without following that procedure, it may not be legally enforceable. Request the meeting minutes. Request the recorded amendment. If they can't produce it, the rule may not legally exist. Fourth, state statutes governing HOA authority. Every state has them. In Ohio, it's ORC Chapter 5312. In Florida, it's Chapter 720. In California, it's the Davis-Sterling Common Interest Development Act. These statutes set limits on fine amounts, notice periods, lien thresholds, and inspection rights. Your HOA's CC&Rs cannot override these statutes. When a board acts outside them, they are not enforcing community rules. They are violating state law. Fifth, certified mail and documented evidence trails. Every letter you send to your HOA should go certified mail. Return receipt requested. Every verbal conversation should be followed by a written summary email. Per our conversation today, keep a dated spreadsheet. Keep copies of everything. In a board meeting, in a courtroom, or in a settlement negotiation, the person with the paper trail almost always wins, especially when the other side stopped documenting the moment things got legally complicated for them. Diane Hartwell resigned from the HOA board 6 weeks after that meeting. 2 of the 14 neighbors who attended that Tuesday night meeting subsequently filed their own disputes against the board using the same document framework I had assembled. Both cases were resolved in their favor within 90 days. The community hired a professional HOA management company to take over administrative duties. The new company's first act was to conduct a full audit of all outstanding violation notices issued in the prior 18 months. Of the 41 active violation cases reviewed in that audit, 27 were dismissed due to insufficient documentation of regulatory authority. 27 families in one neighborhood who had been living under the threat of fines and liens for actions that the HOA had no documented legal right to penalize. That is not a quirk. That is a pattern. And it is exactly why understanding the structure of your property rights is not optional. It is essential. People sometimes ask me if I feel bad about how things ended for Diane. Honestly, no. Not because I'm vindictive, but because the harm she caused was real. Families in my community were paying fines they didn't owe. People were losing sleep over lien threats. One neighbor had stopped parking in his own driveway out of fear of another notice. When authority is exercised without legal basis, it causes genuine damage to real people. The law exists to stop that, and it worked exactly as it was designed to. The workshop is still there, still permitted, still mine. I added a second lock to the gate, a heavy-duty commercial-grade deadbolt with a tamper-evident seal. Not because I'm worried about the HOA anymore, but because boundaries matter, physical ones and legal ones. The gate stays locked. My property stays mine. And every time I fire up the arc welder in there, I think about that silver Mercedes and exactly how much paperwork it took to make sure it never came back. If you take one thing from this story, take this. Your home is your most significant legal asset. The HOA can fine you, warn you, and write letters with bold red text at the top. But they cannot override your deed. They cannot override your state statutes. They cannot enter your private property without legal authority. And when they try, the law gives you tools. Real, documented, enforceable tools. The key is knowing they exist before the silver Mercedes shows up in your workshop. The reason stories like mine end well is not luck. It's documentation. It's certified mail. It's a surveyor with a state seal. It's an attorney who knows ORC 5312. It's showing up to a board meeting with a stack of papers and the patience to let the law do the talking. None of that is complicated. All of it is learnable. And that is exactly what this channel exists to help you do. If this story helped you understand something about your own property rights, I want to hear from you. Drop a comment below. What would you have done when you found that Mercedes in your workshop? Would you have called the sheriff first or the attorney? Would you have gone to the board meeting? Would you have paid the fines just to make it go away? There are no wrong answers, but the conversation matters. The more we share these experiences, the better prepared every homeowner becomes. If you haven't subscribed to HOA Problems yet, now is the time. Every week we cover real property disputes, real CC&R breakdowns, and the actual legal frameworks that protect homeowners in every state. Like this video if it gave you something useful. Share it with a neighbor who's fighting their own board right now. And remember, your property line is also your legal line. Know where it is, document it, and defend it. We'll see you in the next one.